Join. Okay, you've already started recording. I see people quickly getting in the webinar. This is absolutely great news. My name is Patrick Campbell. I'm at James Madison's Montpelier and specifically the Center of the Constitution. Folks are coming in every second. We are going to get started here soon with Dr. Julie Suk. She's in New York right now. Busy schedule with her. If you would put in the chat, if you were willing, where you're dialing in from, that would be wonderful. Not at all required, but it's wonderful just as we're trying to get people lined up here. I think I'll go ahead and get started. We've got about a week of material and we're going to keep it to an hour. With a professor and scholar like Julie, this is a lot of fun. So folks are coming in from New Jersey and Pennsylvania and Ohio, all over the place. This is wonderful. Washington State. Wow. So we're on the eve of Women's History Month. And in just a few hours, we'll be in Women's History Month. And so I asked Julie, and she very graciously agreed to speak with us. I am a constitutional generalist, and I am just super excited that the Virginia Law Foundation is supporting this webinar and allows us to get a scholar like Julie. She is widely published. I could take up 5 minutes with citing her articles and book chapters. She's also got a 2020 book called We the Women, The Unstoppable Mothers of the Equal Rights Amendment. And she has a forthcoming book coming out this year about after misogyny, how the law fails women and what to do about it. She has previously taught at the City University of New York, the Cardozo Law School, Yale, Harvard, Columbia, University of Chicago, UCLA. She's currently at Fordham University. She has a doctorate in politics from Oxford University and her Juris Doctor from Yale. And we were chatting before we started because she submitted written testimony today to the Senate Judiciary Committee. And that's why I say we have a week of material and we're going to try to get it done in an hour. The Senate Judiciary Committee had a hearing on the Equal Rights Amendment. So welcome, Julie. Thanks so much. I heard you're going to take me all the way back to 1780s and James Madison, and I greatly appreciate that.
Thank you so much, Patrick. I'm really grateful to Montpelier for inviting me to do this webinar today and the Center on the Constitution. I've had a wonderful time at the Center on the Constitution at Montpelier over the last, I'd say like 5 to 7 years, presenting my scholarly work about the Equal Rights Amendment and comparative constitutional law, about equality clauses in constitutions around the world. So I'm really thrilled to be back, and I've enjoyed working with your high school educator workshops as well. And I'm thrilled to be back particularly, although only virtually, for this Women's History Eve lecture on women and the Constitution. It's so much more. It's about so much more than the 19th Amendment. And to understand how much more it's about, like all things, we're going to go back to James Madison. And we're going back to James Madison's recognition in Federalist Paper number 43 of the importance of amending the Constitution. And indeed, our provision in the US Constitution, the 1787 Constitution, of which James Madison was an important and principal architect, included Article 5, and Article 5 was designed with the following concerns as articulated by James Madison in mind. He said that useful alterations will be suggested by experience could not but be foreseen. It was requisite, therefore, that a mode for introducing them should be provided. The mode that was preferred by the convention guards equally against that extreme facility which would render the Constitution too mutable, and that extreme difficulty which might perpetuate its discovered faults. So there was an interest in making sure that the Constitution would not be amended at the political whims of whoever was in power, on the one hand, but on the other hand, this balance of trying to find a process that would make it not so difficult that whatever the flaws or faults were in the Constitution would never be corrected. And one of the very important faults that Americans discovered about the Constitution was that its provisions guaranteeing liberty and equality did not initially protect everybody. It did not protect all persons. Black people were not assumed to be legal persons or citizens until the 13th, 14th, and 15th Amendments were adopted after the Civil War. And women were not accorded equal rights even under those amendments, the 13th, 14th, and 15th Amendments. And many states denied women the right to vote until the 19th Amendment was ratified. All of these amendments that I've mentioned were pursued under Article 5 of the Constitution, which provides that Congress proposes amendments by a 2/3 vote in both houses, and then the amendment is ratified by 3/4 of the states, either by their legislatures or by ratifying conventions in those states with Congress to determine the mode of ratification. There's also an option within Article 5, which has never been used, which is the possibility of state legislatures petitioning Congress for a constitutional convention. And then if Congress calls that convention and their amendments that then get sent out for ratification, again, Congress would have the power to designate the mode of ratification, whether it's by state legislatures or by conventions elected in the states for that purpose. And I should also mention all of the amendments that we have, all 27 amendments, with the exception of the 21st Amendment, which repealed prohibition. They were all adopted by 2/3 of both houses of Congress and state legislatures ratifying. The repeal of prohibition, the 21st Amendment, that's the only amendment where Congress designated the mode of ratification as being by conventions elected in the states. And that was in no small part due, I just want to mention, because we are here on the eve of Women's History Month, that was in no small part because there were women's organizations for the repeal of prohibition who really underscored the point that state ratifying conventions might be a better way of ratifying the amendment democratically in the states. So as a historical matter, if we think about the amendments that I've mentioned, these are amendments, the 13th, 14th, and 15th Amendment and the 19th Amendment that are trying to fix the flaw that I've mentioned, that we've come as we've evolved as a society and as a constitutional democracy. We've come to realize that less than equal rights for Black people and less than equal rights for women is a flaw of the Constitution that needs to be corrected by amendment. But what's very interesting is that these are faults and flaws that were perpetuated for quite a long time before the Article 5 process actually worked to correct them. And so even at the founding, there were people who opposed slavery. There were founding fathers who opposed slavery, not all of them. There were abolitionists who wanted slavery outlawed, even at the founding. Our Constitution reached a compromise and did not outlaw slavery until 8 decades later. And even though the Women's Rights Convention at Seneca Falls in 1848 demanded women's suffrage and demanded equal rights in many respects within the legal system, our Constitution did not outlaw the denial of the vote on account of sex until 1920, again, about 8 decades after the idea was put into circulation and a movement was created. So based on that, it does seem fair to say that Article 5 makes it extremely difficult, and even when successful, extremely slow to change the Constitution, particularly when the fault that's being corrected, there are a lot of different kinds of flaws or faults in the Constitution, but when the fault that's being corrected by the amendment process is the exclusion of some people deemed inferior or unworthy of citizenship, it seems that Article 5, even when successful, is an extremely slow and arduous process. And this fact about Article 5 is really important to understanding why women have been fighting for an equal rights amendment for 100 years without it yet being formally recognized as part of the US Constitution today. So I want to use this time that we have together on the eve of Women's History Month in 2023 to think about women in the Constitution, which is certainly about much more than the 19th Amendment, to reflect on what the history of women's efforts at changing the Constitution and correcting its faults means for our constitutional democracy moving forward. And totally coincidentally, as this lecture was planned many months in advance.
Really was.
It really was. It was actually planned before the current Congress was even elected, I think.
Yes.
But we got the latest installment very coincidentally this morning in this ongoing saga about women and the Constitution in the Senate Judiciary Committee, because they ended up scheduling a hearing for this morning on the proposed resolution that would recognize the Equal Rights Amendment as ratified and part of the Constitution, despite its somewhat checkered procedural history of late ratifications by some states and efforts to rescind ratifications by other states. And so I want to read the text of the Equal Rights Amendment. The first section says equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. The second section gives Congress the power to enforce it. It says the Congress shall have the power to enforce by appropriate legislation the provisions of this article. And the third section says the amendment shall take effect 2 years after the date of ratification. And with slightly different wording, authored by the suffragists who had finally succeeded in getting the 19th Amendment ratified, the Equal Rights Amendment was introduced in Congress in 1923, but it really just did not get off the ground, did not get 2/3 of both houses of Congress for 50 years. That is, to get 2/3 of both houses of Congress in the same legislative session, we had to wait until the 92nd Congress in 1971 and 72. Notwithstanding the fact that the Senate passed it a couple times in the 1950s with different wording, and the House passed it once in 1970 prior to this. But in 1972, when both houses of Congress finally adopted the Equal Rights Amendment, they adopted it by over 90% of the members of Congress voting for it. But one thing that was remarkable but not remarkable is that it included a 7-year deadline on ratification. There had been versions of the ERA, including the one that was overwhelmingly adopted by the House in 1970 without a ratification deadline. But as a concession to very fierce opponents who insisted on the deadline and still voted against it, even with the deadline in, the ERA sponsors agreed to a 7-year deadline in the resolution introducing the proposed Equal Rights Amendment. And that paragraph, including that deadline, says that the proposed article, the ERA, which I just read, will be valid to all intents and purposes as part of the Constitution when ratified by the legislatures of 3/4 of the several states within 7 years from the date of its submission by the Congress. And the reason it remains controversial today is that only 35 states ratified the ERA in the first 5 years, coming 3 states short of the 38 necessary to get to 3/4 of the 50 states. Ratification stalled as a very powerful Stop ERA campaign was launched in many of the battleground states, including Illinois. Congress voted to extend the timeframe by another 3 years in 1978, but no additional states ratified the ERA until 2017, when Nevada did. And then Illinois ratified in 2018, and Virginia in 2020. Meanwhile, 5 state legislatures took action during the period in the 1970s before the deadline had elapsed. They took action to reverse their ratifications. They tried to rescind their prior ratifications. And that brings us to this morning's hearing at the Senate. In the last 2 Congresses prior to this one, the House actually took majority votes to remove the deadline on ERA ratification. And the hearing this morning was about a new resolution, Senate Joint Resolution 4, which reads, resolved by the Senate and House of Representatives of the United States of America and Congress assembled that notwithstanding any time limit contained in House Joint Resolution 208, 92nd Congress, as agreed to in the Senate on March 22nd, 1972, the article of amendment proposed to the states in that joint resolution is valid to all intents and purposes as part of the Constitution, having been ratified by the legislatures of 3/4 of the several states. And this resolution raises a really important constitutional question under Article 5. It's a difficult constitutional question, which is, first of all, does Congress have the power to impose deadlines on state legislatures ratifying constitutional amendments? The text of Article 5 doesn't really speak to it. Can Congress change a deadline that it imposed previously? Again, text of Article 5 doesn't speak to that. And then if Congress can decide to lift the deadline, that is, to excuse the extremely tardy states who ratified recently and presumably reject the rescissions of the states that are trying to take back their ratifications, if that's actually legal under the Constitution, that still would not answer what's essentially a political question, which is if Congress can do this at all, should they do it? Are there good reasons to allow the late ratifications or to deny the rescissions? And I want to say that these questions really matter, not only because of the Equal Rights Amendment or because of women, which they certainly do, but also for the way that we understand Article 5 amendments and the role of the people and of Congress in changing the Constitution. Specifically, Article 5 is very spare. It says a lot of things which we've already covered, but there are so many things it doesn't address. How should we understand them in the future? Since the controversies associated with the ERA, Congress has actually not really done a lot with Article 5. After the ERA ratification process stalled in the 1970s, there was one more instance where you got a 2/3 vote in both houses of Congress to propose an amendment to the states. And that amendment, which was an amendment that would have given voting rights to the District of Columbia, adopted in 1978 by both houses of Congress, ended up getting far fewer ratifications than the ERA within its 7-year time period. And so a lot of people, a lot of scholars suggest that the Article 5 is just functionally dead or irrelevant because there's been so little Article 5 activity. And indeed, the only amendment that has occurred in my sort of adult life, 1992, I was 1 year shy of being old enough to vote. That's the only amendment that was added to the Constitution. And that was already 31 years ago. And that amendment, with all due respect to James Madison, was written by James Madison himself. It took 203 years to ratify that amendment, and it was added to the Constitution in 1992. We haven't had an amendment since then, which is to say that Congress hasn't passed an amendment since way before 1992, and the last one we had was actually written by James Madison. So that gives you a sense of how far out we are from we the people really thinking about Article 5 as a serious path by which constitutional change can happen. And so to really think seriously about what the Article 5 process says about the power of Congress and about deadlines, we need to focus not only on women and the amendments that seem explicitly addressed at improving the condition of women, whether it's the 19th Amendment or the ERA, but how these amendments that are about women's rights compare to the process of making other amendments to the US Constitution. Since the Prohibition Amendment, which, by the way, sometimes people don't realize this, women actually played a very important role even before they had the right to vote in advocating and agitating for the Prohibition Amendment. And they did that largely because alcohol was a social problem that was associated with many issues that a lot of women, especially women who belong to the Women's Christian Temperance Union, cared about, including things like domestic violence. But since the Prohibition Amendment, Congress has actually put deadlines on the ratification of constitutional amendments. And it's really important to note and examine how Congress framed those deadlines, starting with the Prohibition Amendment. Specifically, Congress used very different language to make it clear that the amendment proposal would expire if it was not ratified within 7 years. And so if you look at what they did with prohibition, not only did they use very strong language, they also put that language into the text of the proposed amendment itself. So if you open up your pocket constitution, and I always keep one from Montpelier on my desk. I'm not going to pick it up right now. That's the one I have too. Pick that up, see that Section 3 of the Prohibition Amendment says, this article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states as provided in the Constitution within 7 years from the date of the submission hereof to the states by Congress. So it says inoperative unless ratified within 7 years. And you have Congress repeating that language and sticking it into the text of the amendment with the 20th, 21st, and 22nd amendments. But the language is very different in amendments after that. Specifically with the ERA, they didn't even put the deadline into the language of the constitutional amendment itself. They put it into the resolution introducing the amendment, and they said when ratified within 7 years. So inoperative unless, expiration date, dead if you don't get it done within 7 years. Valid when ratified within 7 years. A little bit different. It makes it clear if you get it done in 7 years, it's definitely part of the Constitution, but silent, ambiguous on what happens if you don't get it done within 7 years. So arguably what you have there is something that would be more akin to a target date, which was Congress's theory when it came back to changing the deadline on the Equal Rights Amendment. And now in the resolution today, Congress is proposing to just remove the deadline altogether, believing that it has the power to change the deadline when it's framed in that way, both linguistically as well as its placement in the preamble as opposed to the text of the constitutional amendment.
And these date discussions are not in Article 5. So you've mentioned the spareness of Article 5. Yet it has 2 proposal ways and 2 ratifications. So maybe if, as we talk about how our Constitution could change, the 2 proposal ways, you mentioned we've never used one. We haven't had a convention since 1787. Mm-hmm. With your knowledge of the world, the idea that you have to have 2/3 of both houses propose or 2/3 of the states call a convention. Is this odd that over 200 years, we've never had another constitutional convention? Do you see in other democracies, you'd much more have a convention to meet on the issue of updating your constitution?
Well, many of the states have had constitutional conventions as recently, although I don't know if you consider it relatively recently. I think the last one might have been in the late 80s. Or possibly even early 90s, but certainly a lot of the states have had conventions throughout the 20th century pursuant to their state constitutions. And this is actually a really important point, Patrick, that we think of Article 5 as extremely difficult to amend, and that's a comparative statement, 2/3 of both houses of Congress and 3/4 of state legislatures. And it's a comparative statement because most of the state constitutions are easier to amend, and they have a different rule. It's not like absolutely, it's not the same as just passing ordinary legislation. But in my state, for example, in New York State, the rule is that the legislature has to pass it twice in 2 consecutive legislative sessions, and then it goes to a referendum by the people in the following election cycle. And this is a very common formulation. A lot of states have some variation of that.
Similar in Virginia.
Yeah, and a lot of states also have a ballot initiative. where citizens can petition, and as long as they get a certain number of signatures, then it goes on the ballot for a referendum to amend the Constitution. And this is also a really interesting and important point, which is that Article 5 doesn't really put the people directly involved in amending the Constitution. It is true that there could be a constitutional convention, but to call one, you'd have to go through your state legislature. The people themselves would not get together and call a convention under Article 5.
So two big points you've raised, I think, in terms of federalism and the people's advocacy to get this proposal process started. Maybe on the federalism point first, because I think this really plays, we see this in the 19th Amendment, and maybe we see it in the ERA proposal of states having women voting before the federal government guarantees it. And so do we see this, does Madison's idea of federalism, does it actually help this, laboratories of democracy that we get to see something in the states and then that causes the national government to catch up in cases like this?
Well, it's quite complicated because absolutely, the 19th Amendment is both made possible and made necessary by the laboratories of democracy. Let me explain what I mean. So there are women voting in the West well before the 19th Amendment. And one of the strategies by the suffragists was to say, let's just go state by state. Every state should have its own process by which they change their state constitutions, and they make it possible for women to vote. And a lot of the states, including my state, New York, had women voting before the 19th Amendment was ratified. But there were a lot of states that were reluctant. And so you had different rules and, basically unequal suffrage between women living in certain states versus women living in other states. And this is why some of the suffragists thought that it was so important to have a federal constitutional amendment as the strategy. In much the same way with slavery before the Civil War, some people thought we should have some slave states and some non-slave states. And you get a civil war because they realize that it's really not possible to stay together as a union with some slave states and some free states. And so I think similarly, the movement to get a federal amendment was that you really needed a federal amendment because there were certain, like the experimenting with not having women voting was something that in the modern constitutional democracy era was no longer something that should be left up to the state legislatures. And so that's really, and of course, with the ERA story, it's really interesting too, because if the process by which you get an amendment is state legislatures ratifying, which is different from the people voting to ratify that amendment. Yes, it is true that people vote for the representatives in the state legislatures, but if you have dynamics in the state legislatures, for example, gerrymandering, or dynamics in the state legislatures where there are certain committees where people who are powerful in the committees control whether or not a proposal for a federal constitutional amendment goes up for a vote. Even if you might have a large percentage of the electorate supporting something, it could end up being that it never gets voted upon by that state legislature. And so then this raises a question: to what extent is every state a laboratory of democracy? We should hope that under the original design of federalism, every state is a laboratory of democracy. But scholars are increasingly interested. Jacob Grumbach, a political scientist, is one who wrote a book recently published called Laboratories Against Democracy. I think scholars are becoming much more aware and studying the ways in which different state legislatures can act in very democratic ways, and other state legislatures are not very democratic at all. And these are all things that we need to think about as we consider the extent to which the process that we have for amending the Constitution in Article 5 is itself democratic and reflective of the people of the country.
And folks can type into the chat if they want. I'm fascinated listening. I guess we talked a little bit about the proposal. The ratification process needs 3/4 of the states. I think you mentioned it could be both state legislatures or state conventions. Do I hear a little bit in the 21st century, it could be referenda by the people directly, because right now it's very indirect, right? It's either a state legislature, we vote for our legislators, or a state convention that we would send delegates to, which you're saying prohibition did, right?
No,
To end
no,
prohibition.
I want to, no, so let me be clear. So if you have a constitutional convention to propose amendments, which we've never done,
Right.
that would be 2/3 of the state legislatures
Right.
petitioning Congress. Article 5 is also totally silent on how you would organize such a convention if one were called. Would you have one delegate per state? Doesn't say. Would you do it? Would you proportion? Would you do proportionately? Would the states even matter? Would you just have a national election? Or would you not even have an election? Is that even necessary to call a convention?
Or if only 2/3 of the states showed, not all the states were at the convention?
Right. So that's totally like uncharted territory. What I mentioned about the state ratifying conventions with regard to the repeal of prohibition is something different, which is how does it get ratified once Congress proposes an amendment? And so with the repeal of prohibition, Congress designated the mode of ratification as being state conventions. And what that meant was that they had elections, but it's kind of like a referendum, because they're not having a convention to talk about prohibition. You're having a convention to ratify the repeal of prohibition. So you're electing your delegates to that convention based on a pretty simple question. Are they going to vote yes or no to the text of the 21st Amendment, which has already been written by Congress and sent out to the states for ratification? So that's very different from having a constitutional convention for the purpose of proposing amendments, about which Article 5 says nothing about how that would be designed or regulated. And it's an interesting question, of course. But for the most part, all of our amendments have been, and generally, I noticed that when people write proposals, or sometimes there are bills in Congress proposing a constitutional amendment now on various subjects, they almost always choose the state legislature method of ratification rather than the state ratifying conventions method. Although it's my view that using the state ratifying conventions method functions much more like a referendum, because you're just voting for people who are going to clearly vote yes or no. Whereas when you vote for your state legislator, you're not voting for a state legislator who's clearly going to vote yes or no on anything. They're going to consider a whole range of issues because they're going to be your representative, including possibly the ratification of a federal constitutional amendment. But I love the questions that you're raising, Patrick, because I think it really kind of opens up what's in Article 5, what's not in Article 5, what are all kinds of Article 5 possibilities that we haven't used very much in our Constitution, and then what are the things that we sometimes assume that Article 5 answers, but doesn't necessarily. And so if we get back to this whole idea of Congress having the power to give the states a deadline, whether it's an expiration date or a due date, like a target date, this is a really interesting question when you look at the history of the 19th Amendment, because after Prohibition, a lot of the opponents of women's suffrage wanted a 7-year deadline on the 19th Amendment. And they wrote it to look exactly like the 7-year deadline on the Prohibition Amendment, inoperative unless ratified within 7 years. And if you look at the legislative history, all the hearings that they had on the 19th Amendment, Carrie Chapman Catt, a lot of the suffragists who testified or submitted written testimony to Congress during that period really objected to the 7-year ratification deadline on the 19th Amendment. And they objected to it because they knew that sometimes it's really hard to get change in some of these state legislatures. A lot of these state legislatures had rules about when you can introduce an amendment. Like if they vote once and it doesn't pass, then you have to wait 2 or 3 years, maybe 5 years to introduce it again. So they were genuinely worried that if you had a deadline on the ratification of the 19th Amendment, it wouldn't get ratified. And it turns out, because of World War I, there was a real push, and the 19th Amendment actually did not take very long to get ratified by the requisite number of states. But I think it is very telling that women who had been in the movement advocating for women's suffrage for such a long time really thought that the 7-year deadline would be a death knell for something proposing such a huge change as having women vote and having a constitutional right, or at least a constitutional guarantee that the states couldn't take away a citizen's right to vote on the basis of sex. And this is also really important to consider as we get to the ERA, in part because the ERA, discussions of the ERA are also beginning right around exactly at the time that the 19th Amendment is ratified, because the suffragists, although they didn't all agree on this, but many of the suffragists believed that the vote was just the beginning. They said they believed that they were advocating for the vote so that women could have equal rights in many other areas, including the right to own property if they were married. That was something that had begun to change, but married women's property rights had been something over which women had been fighting since the 19th century, because women's rights over property, or just rights to be equal in the context of professions and business relations. These were all things in question. So they believed that the Equal Rights Amendment was the logical next step after the 19th Amendment. And what's really interesting about that proposal is that even though the Equal Rights Amendment is not adopted and ratified and added to the Constitution, over many generations, that process of advocating for a constitutional amendment made enormous changes to the law of gender equality. And so when you get to the final, well, not final, but very pivotal and important moment when Congress adopts the Equal Rights Amendment in 1972, that's exactly the time when Ruth Bader Ginsburg successfully argues in many landmark equal protection 14th Amendment cases that the equality of women, non-discrimination on the basis of sex, should be something that is enforced with regard to the 14th Amendment's Equal Protection Clause. Prior to that, the Supreme Court did not think that gender discrimination was a problem under the 14th Amendment's Equal Protection Clause. But this changes, and it changes in part because the movement for the ERA is saying that loud and clear.
And let me pause, because this is one of our questions too, and this is unfair to try to get this in a 1 hour, but the equal protection language of the 14th Amendment and the Equal Rights Amendment, the language of shall not be denied or abridged by the United States or by any state on account of sex. So there was a question about that in the chat. You alluded to it with one of Justice Ginsburg's opinions. How should I think about these arguments that the Equal Protection Clause of the 14th won't protect what's being advocated in the Equal Rights Amendment? Right. And I know there's opinions on all sides, so that's why it's an unfair question.
It's a really excellent and important question, because throughout the entire period and currently, people have different ideas about how the Constitution should be interpreted. And so with the 14th Amendment, Ginsburg argued that equal protection of the laws meant that everybody that you regard as a citizen needs to be treated as an equal citizen under the law, which means that if the law makes distinctions or discriminates against someone on the basis of sex, that is an equal protection violation. The courts had rejected such arguments before 1971. But in 1971, the court changes and starts saying, oh, if there is a distinction that's made by sex under the law, we're going to scrutinize that. And so they develop a whole set of doctrines. I don't want to get too much into the weeds about the doctrines by which the court starts saying when the law discriminates on the basis of sex, that's unconstitutional under the Equal Protection Clause. I think the reason there's a concern about the extent to which the 14th Amendment can protect women's rights nowadays is because of another judicial philosophy that's become very important on the current Supreme Court. And that's a judicial philosophy that says that the meaning of the text in the Constitution depends on its publicly accepted meaning at the time of ratification. And if you take that very seriously, the 14th Amendment was ratified in 1868, and that's before women had the right to vote. That's before women had property rights in some, married women had property rights in some jurisdictions. That's before most parts of the legal order really treated women as fully equal citizens with the same rights as male citizens. And so the worry there is if you freeze constitutional meaning at the time of ratification, then the 14th Amendment may not necessarily protect women's equal rights, whereas the Equal Rights Amendment was introduced precisely with a clear goal of changing that. And then the time of ratification, 1970s to 2020, that makes clear certain modern understandings of gender equality that probably did not exist in 1868. And so this is why there's this sense that the Equal Rights Amendment, if added to the Constitution, would create a much more obvious and stronger source of sex equality than the 14th Amendment has done thus far. Although that's not to say, to advocate for the ERA, that's not to say that the 14th Amendment is useless.
Right. Not at all. And so talked a little bit about the difficulty of proposals, but the difficulty of ratification, needing 3/4. And one of the questions was about, how indirect do we want our democracy to be? How direct do we want it to be? And still in the ratification process, there's not the ballot referendum like you've mentioned in New York, as well as it's also in Virginia. I don't know how many states. So are we kind of stuck with this indirectness of 1787 Article 5? And should that be looked at in terms of the ratification of the proposal process, that we should have a more direct ability as citizens to change our Constitution?
So I'm so glad you asked that question, Patrick. And I don't know if it's also coming from the chat, because this is a very important question. Unlike the states, we don't have a process by which the people can directly change the Constitution. And the Article 5 process, because it requires 2/3 of both houses of Congress. Now, when you have very partisan polarization, it's so hard to imagine 2/3 of both houses of Congress agreeing to anything. And 3/4 of the state legislatures. That makes it incredibly difficult. And you might think that you might have a better process if it were possible for us to have like a national popular vote, for example, to ratify a constitutional amendment. But that's not something that Article 5 contemplates. So one answer to that is maybe there are ways that we can make the Article 5 process more democratic, more directly democratic. So, and the answer has to do with, think about the 7-year deadline. Article 5 says nothing about it. But Congress has assumed for about a century now, and the courts have essentially agreed that Congress has power to, it's part of its power to designate the mode of ratification, to put timelines on ratification, not mentioned by Article 5, but a little tweak that Congress can make. So one question is, what if Congress were to say, and I'm not inventing this idea, this has been used in other countries. What if Congress were to say, before we vote in Congress, since we're so polarized anyway, before we vote, why don't we just have a referendum, not a binding referendum, but why don't we just have a referendum to see where the American people stand on this constitutional amendment proposal? Let's have a referendum to see if most American voters want the Equal Rights Amendment, for example. And you have a referendum, and then Congress, that puts political pressure on Congress. Congress can then say, wow, wouldn't it be shameful if we know that, say, 95% of the American voters voted for a particular amendment, and it doesn't have to be ERA, it could be any proposal, but if 95% of the people or 80% of the people wanted that, it would be kind of, I think, shameful for members of Congress to not vote for it, or at least you would consider that kind of anti-democratic. And so what I mean when I say this, something like this exists in other countries, I'm thinking of a country like Ireland, which has made very innovative use, not necessarily of the referendum, because the referendum is actually part of their constitutional amendment process at the ratifying back end stage, but at the front end stage. proposals. They have convened citizens' assemblies over the last several years on amendments that are on socially sensitive subjects, including abortion, including same-sex marriage, those kinds of issues. They know that they're on sensitive subjects, so they really want to know where the Irish people stand. And so even though it's not mentioned in the Irish Constitution as a way of amending the Constitution, what they did was they convened citizens' assemblies, kind of like the way we do juries. They randomly selected citizens based on different geographic regions and across a range of age spans and, equal numbers of men and women, that kind of thing. And they had citizens' assemblies deliberate over several weekends in a year about proposals on what to do about same-sex marriage, what to do about abortion. They've had one in the past year and during the pandemic about gender equality and whether or not the Constitution, how the Constitution should value mothers and caregiving and its relationship to gender equality. And it's quite likely, based on what the parliamentary committees have said so far, that there will be another referendum in Ireland now on some of those amendment proposals. So the idea is that there's room for innovation because Article 5 doesn't say so much. There is room for innovation if Congress were willing to incorporate certain more democratic elements, either at the front end or the back end. At the back end, the option of picking ratifying conventions to ratify a constitutional amendment is an important example of how, if Congress just chose that, that's actually already in the Article 5 menu, but if Congress chose ratifying conventions instead of state legislatures, that might function as more directly democratic because people would be essentially voting on a delegate who's going to vote yes or no on that amendment, rather than voting on a representative who's going to vote all kinds of things on all kinds of legislative proposals.
And I'm going to ask you about a hero, Julie, and you pick. But we've been talking about the process of the Constitution, the law and proposal, but obviously we're talking about sisters and mothers and sons and that. So help me out with maybe somebody I haven't heard about or somebody I don't know enough about, a woman who's really done so much to change the Constitution or their government. Whether it happened in their lifetime or not, but maybe somebody who's inspired you because of the way they've fought for change.
So, Patrick, I love and hate this question because there are so many women.
Right.
And I would hate to just pick one. And so I do want to flag that my book, We the Women, The Unstoppable Mothers of the Equal Rights Amendment, tells the stories of many of the women who explicitly fought for the Equal Rights Amendment, but also some of the precursors, including Abigail Adams, the wife of John Adams, who in her letters to John Adams talked about the importance of remembering the ladies in drafting the Constitution. And certainly I think about some of the women who were in Congress at the time that the Equal Rights Amendment was passed. And I think one person who's really worth highlighting in this conversation on the eve of Women's History Month is Martha Griffiths. And it's because she was in Congress and she was the sponsor of the ERA, but that's not why I'm highlighting her necessarily. It's that in order to get the ERA even debated on the floor of the House of Representatives, she had to do a discharge petition. And she had to do a discharge petition. This is also an interesting problem. Many people supported the ERA and many members of the House supported the ERA in 1970. And in fact, many of them supported the ERA throughout the 1960s. But it never got a floor debate because the chair of the House Judiciary Committee did not want the ERA. This is Emanuel Seller, who's from my state, New York. So because of that, the Judiciary Committee, the House Judiciary Committee did not report out the ERA. And the only way you could even get a debate on the ERA, people talking about it in Congress, is to do a discharge petition, which is what Martha Griffiths did. She just kind of rolled up her sleeves and talked one-on-one with all these House members until she got more than half of them to sign her discharge petition. And once that discharge petition was done, she got a debate in the House. And what's incredible is that even though they couldn't get it out of the committee. Once it got to the floor of the House, well over 96% of the people who were there and voted for the ERA. And this is also an example of just thinking about democracy, that sometimes we might have processes and ways of doing things, committee power, the way certain bodies work that don't necessarily reflect the will of the majority or the will of the people. And I think this is a really good example where she saw that the institution she was working within would not give the ERA a hearing, but there was another procedure, the discharge petition, which involved much harder work. She had to talk one-on-one and get signatures of like individual members just to get a debate on the ERA. But once the ERA got a debate and people could really consider it and think about it in earnest and hear arguments against it, they voted for it. And I think that's really a heroic story about democracy. And also really important to that story, she was a Democrat, but she worked very closely with Republican women in the House who did not all agree on all the particular policy issues surrounding women's rights. Republican women like Margaret Heckler, who ended up becoming very important to ERA advocacy. But I think this is something that I want to highlight, that there's a record of bipartisan collaboration and persuasion that I think that unfortunately we have a little less of today. And I would hope that we have processes by which people can work across different ideologies and different political parties and even make compromises that they didn't imagine in order to make constitutional changes that are needed in the modern age.
I'm going to see if I can answer a question from the chat and have you correct me. What's a discharge petition? Committees are where bills go to die. So bills go into committee and they never come out of committee sometimes, and until the committee votes it out. But a discharge petition, I believe, is in this case when the whole House votes by a majority of the whole House to say we want that out of the committee, even though.
So to put it politely, you are discharging the committee of its obligations, right, with regard to that bill.
So knowing the tactics and strategy, and maybe a tactics or strategy we haven't thought about in terms of how women have changed the Constitution or our government, but knowing our rights in this civic education, is there something we've missed in terms of how maybe we haven't talked enough about protest or litigation, or the ability to appeal to Congress in terms of women updating the Constitution?
So I think that one thing we do need to think about is being more imaginative about the process that we have under Article 5. I will say that part of the reason there's been less activity and less imagination about the Article 5 amendment process is that the normal way of changing the Constitution, which I say normal with scare quotes because it's not normal in other countries, but the normal way in the United States, I say over the last half century of changing the Constitution was to go to the courts, right? And persuade the courts to change and to change radically how they interpret the Constitution. It was a total sea change to say that gender equality was protected under the Equal Protection Clause of the 14th Amendment in 1971, 72, 73, in that period. It was also a very significant change to say that the Constitution, the liberty provision of the due process clause in the 14th Amendment protected a woman's right to terminate a pregnancy under certain circumstances. These are pretty big changes that are not in the text of the Constitution as such, but they're important constitutional changes. And at one point, I think American people got used to going to judges for constitutional change and not using the process of actually formally changing the Constitution, which is understandable given how hard Article 5 makes it to formally change the Constitution. And I would say things like the 7-year deadline What I do want to point out is that the ERA deadline was actually much more like a target date rather than an expiration date that you see in amendments like prohibition and in some of the other amendments that are earlier in the 20th century. By the end of the 20th century, the amendments most closely adopted to the ERA have this much more flexible language, leaving it to Congress to change the time frames for ratification. That's really important because what that shows is some creativity and innovative thinking on the part of Congress with regard to how to modernize the amendment process. And you can modernize it in ways that make it more difficult, such as deadlines or expiration dates, or you can modernize it by trying to incorporate direct democracy elements into the way in which Congress proposes by 2/3 of the House, perhaps by incorporating things like citizens' assemblies or referendum at the front end, or by being more innovative. If you can get an amendment passed, then having ratification by the convention method of ratification in the states rather than relying on state legislatures, because the state legislatures, depending on the states, may be more or less democratic than some other state legislatures. So as a result, I do think that one of the very important lessons of both the 19th Amendment and the current set of controversies about the 7-year deadline on the ERA, one of the lessons is, like, how should we think about Article 5? How democratic is it? And what are ways we can work within what it gives us to make it better and much more amenable to, essentially, we the people making a more perfect union by activating Congress and the state legislatures or state conventions to make changes to modernize the Constitution without relying on the courts to do it for us.
So I think the courts are looking at the Equal Rights Amendment, as we had a DC Circuit opinion. There was one question about rescission.
Mm-hmm.
The thought, can a state rescind, as in the case of the Equal Rights Amendment, I believe 5 states say they rescinded, maybe I have the number wrong, but some states say they rescinded their ratification. How could we think about rescission?
There are many different ways to think about it, but I think the first and most important is looking at historical precedent, which is with the 14th Amendment, there were 2 states that actually rescinded their ratifications of the 14th Amendment, and Congress rejected their rescissions and declared the 14th Amendment ratified. And we would not have had the 14th Amendment at the moment that we got it, or possibly ever, if Congress had not made that particular decision. So that's not to say rescissions should never be allowed. I think it's also, one argument is that because Article 5 just says ratified and doesn't mention rescissions, they can't. I think I'm a little bit more agnostic on that. I think it's just up to Congress to decide as to whether to accept or reject rescissions, and then it becomes a political question. And I think the way that the Congress should answer that question is by really thinking about the extent to which that amendment is necessary and whether it would be fair or unfair to various states to allow the rescission or not allow the rescission. And it's a similar assessment with regard to allowing ratifications that came after the congressionally prescribed timeframe. I think that is a serious question, but I think it's up to Congress and not up to anyone else to decide if a state ratifies late. Should we throw that ratification in the trash, or should we excuse the lateness? I think generally, because Congress is the proposer of the amendment, Congress ultimately has authority to answer that question, both of which are difficult political questions.
And I had a question about bill versus resolution. Is the process of proposal, has it always just been termed a joint resolution rather than a bill? Is that semantics?
So I think it's long been understood that an Article 5 amendment proposal by Congress is not legislation. And that's why the president doesn't sign it.
Right.
It goes to ratification. If it were legislation, if it were like a bill that becomes a law, the president would have to sign it and follow that rule. But an amendment proposal is a proposal to the states and it doesn't become law until the states ratify the reports of the states.
Well, thank you so much for being here virtually and really getting us down the road and thinking about how we should think about our Constitution, how we should think about changing it, how we should think about how people have paved the way before us. These are things we get to do at Montpelier, and hopefully we have good discussions with the father of the Constitution, the architect of the Bill of Rights, and we really rely on great scholars like you, Julie, when you can come here, or in this case, virtually. We thank you for it. We've got Madison's birthday coming up in about 2.5 weeks. So we're going to celebrate that here. But gorgeous weather, as you can see behind me here at Montpelier.
Of course.
So hopefully you come. Thank you so much for you all joining us. There's lots of thanks in the discussion, and appreciate you. Bye-bye. Or do you want to have the last word? I'm sorry. My apologies, Dr. Julie.
Oh, I just wanted to say thank you. Thank you for all the thoughtful questions. And thanks so much to all of the participants and your questions in the chat. I really, really appreciate the opportunity to talk with you this evening.
Good night. Thank you, folks.